Supreme Court on this day ruled that the federal prosecutors, the U.S. Justice Department, improperly charged some of the January 6 defendants with obstruction. The ruling means that as many as 250 who have been convicted or are still waiting a trial on the charge of obstructing an official proceeding could now move to vacate their convictions, their sentences, and their pleas. On January the 6th, 2021, a essentially off-duty Pennsylvania police officer by the name of Joseph Fisher stormed into the Capitol and allegedly assaulted a Capitol Hill police officer. Fisher was later charged with several charges, including several crimes, including obstruction. But as the Washington Post reports, the charge carries a 20-year maximum penalty and is part of a law enacted after the exposure of massive fraud and shredding of documents during the collapse of the energy giant Enron. Writing for the Supreme Court majority, Chief Justice John Roberts said prosecutors' broad reading of the statute gives them too much discretion to seek a 20-year maximum sentence for acts Congress saw fit to punish only with far shorter terms of imprisonment. Here's more from ABC News Supreme Court contributor Kate Shaw as to why federal prosecutors tried to use this obstruction statute to begin with.
The Justice Department took a look at the statute and said it criminalizes otherwise obstructing or impeding an official proceeding. That is broad language, and it applies to individuals who sought to obstruct the counting of electoral votes to certify Joe Biden as the winner of the presidential election. So they thought the statute actually did cover this conduct, and so they went forward with the charge. What the court here says is you have to look both at the context in which this law was passed, but also surrounding language, which makes reference to documents and records. And again, it's not that prosecutors could never charge, storming the Capitol under this provision of law, but there needs to be, again, a connection to the destruction of records and documents, not just, blocking a proceeding.
Translation, if Joseph Fisher and others had actually destroyed, say, the Electoral College documents themselves, then perhaps the Justice Department could have used this obstruction statute passed in the wake of Enron, but because it was simply blocking the proceeding, the court decided, no, you can't use the statute, it is too broad. 80% of the 1,400 people who have been charged in connection with January 6th have not been charged with this obstruction statute. So 80%, this is not gonna affect them. Most of them were charged with either trespassing or assaulting a police officer or resisting a law enforcement officer. However, in the Donald Trump election interference case brought by Special Counsel Jack Smith in Washington, D.C., 2 of the 4 felony charges facing Trump involve the obstruction statute. The Washington Post writes that Special Counsel Jack Smith, who brought the case against Trump, has previously argued that even if the Supreme Court ruled in this direction, the criminal charges against Trump would still stand. However, soon after today's decision, Donald Trump posted on social media, True Social, big win, big win. Cenk, your thoughts?
Thanks for watching. Our audience has helped build TYT into the media giant it is today. Together, we can accomplish anything. Support our work and join us at tyt.com/team.
So mixed on this for 2 reasons. First, on the issue of the statute itself, is it a little too vague? Am I worried about it? Yes. Why? Because when you say a protest is obstruction, well, then you could really outlaw a lot of protests, and I do not want to go in that direction, and that's a terrible idea. Now, having said that, if this is an obstruction, what is? They literally interrupted the certification of the election with the intent of interrupting and obstructing a government act, and a monumentally important government act. And not only that, it was intended to cause delay so they could bring in the fake electors from the states and pretend that they were the real electors. It doesn't get any more textbook obstruction than this. If they didn't mean this by obstruction, what did they mean? Well, you have to interrupt the proceedings, you have to break and enter, you have to take over Congress, but plus what, you have to burn a specific tonnage of documents? I mean, what kind of absurd interpretation is this? So, okay, so I guess, but you know what's gonna happen? I mean, this is what's wrong with a deeply, deeply politicized Supreme Court. When it comes to the left wing, they'll probably say, oh, you walked by the Capitol, obstruction. When it comes to the right wing, oh, you took over the Capitol, you delayed the proceedings so that you could help Trump do a coup with his fake electors. I don't see it. I don't see any obstruction. If they didn't mean this, what in the world did they mean by this statute? The Supreme Court is a bunch of liars. They know that this is exactly what obstruction is. They don't give a damn. They just want to let the January 6th guys off. All right, Farron, what do you think?
No, I agree with you on a lot of that. But I will add, when you look through this ruling, there is a small part that Chief Justice Roberts put in there that basically, well, it exactly says, the government has an obligation to prove a defendant impaired the availability or integrity for use in an official proceeding of records, documents, objects, or other things used in an official proceeding or attempted to do so. That phrase right there actually does leave open the possibility that a lot of these obstruction charges are going to remain. Now, obviously not for all of them, and I do think there's a good chance these 2 charges against Donald Trump could be dropped just for the ease of things for Jack Smith. But I think a lot of these Capitol rioters are still gonna find themselves facing these charges because this is not necessarily just a blanket, you can't do this at all. When we're talking about people that are in the actual chamber, obviously that would fall under Robert's own definition of things used in an official proceeding, right? We can't be in the Capitol because you're crawling over our chairs with a bunch of zip ties in your hands. You're walking out with the podium. What are we supposed to do at that point? So there is some wiggle room there for prosecutors at the DOJ to still bring some of these charges depending on who the individual is and their specific case. But it's going to be very difficult because of this ruling. And if you have them on other charges, it may just be easier at that point to drop those anyway and just say, okay, well, we'll nail you on the trespassing, the assault, and all the other things. We'll just get rid of this one. So, making their lives easier at the DOJ, it may be more worthwhile to look at a lot of these and see where you can drop it, see where you can win it. But it's gonna be a lot of work, and the Supreme Court really did screw them over on this.
What do you think?
Well, and it's screwing over not only, of course, the Justice Department in terms of the prosecution of these January 6th defendants, but I think also it does make life so much more difficult for Jack Smith because he may think he's got a legal theory as to why, because of what Donald Trump did and the incitement and everything, that maybe somehow this does actually apply to obstruction as defined by this Enron statute. But this is going to mean one more set of hearings over that, which will likely delay Jack Smith if he wants to pursue all 4 felony charges. And oh, by the way, it could be delayed even more depending on what the Supreme Court does with the immunity decision. So it's just one more sort of roadblock for Jack Smith in his prosecution of Donald Trump in DC. And it stretches things out. And I think that just has a lot of us pulling our hair out.
Yeah, so my last thoughts on this is, so it makes it sound like they're not obstructing anything because they didn't shred documents or something, right? Well, they obstructed a thing called the certification of the election. Is that not a thing? If that's not a thing, then what is a thing? Is Mike Pence a thing? Because they were planning to obstruct him by murdering him. They were chanting, hang Mike Pence, hang Mike Pence. Is it like, well, no, if they destroyed one piece of paper, then we might have an issue. But if they murdered the vice president, not an issue. I mean, an issue on other crimes, but not on obstruction. But why did they want to murder the vice president? By the way, look at this, guys. Joe Biden is losing to a guy who didn't mind that his supporters were going to murder his vice president. That's Mark Meadows, his chief of staff, told Trump, your fans are going to murder the vice president. And he said he didn't mind. So is Mike Pence a thing? Is it obstruction to kill the guy who would have certified the election? This is not hyperbole. A massive crowd chanting, hang Mike Pence, hang Mike Pence. But the Supreme Court can't find obstruction. Where is it? I can't tell. Oh, it's a right winger? I don't see anything. I don't see anything at all. And then finally, I loathe Merrick Garland for not filing charges instantly and charging insurrection. If a fake elector scheme and a violent takeover of the Capitol is not insurrection, what the hell is insurrection? And why didn't you actually try to prove it? So we can definitively show it to the American people. Or even if you lose, brother, at least we adjudicated it. And then we could be done with it and we could try to heal and unite as a country. But now, nope, whenever it's, now look, I feel like I'm in a topsy-turvy, bizarro world. where some portions of the radical left says if it's our perceived side, there is no crime. And now the right wing says if it's our side, there is no crime. There is no crime you could commit on either side that if you're perceived to be on that side, they would say is a crime. And the rest of us are stuck in this torture chamber of gaslighting. So this country is in deep, deep trouble.
You know, just adding on to, you talking about Merrick Garland and not charging these people with insurrection. It brings me to a point that I had made, all the way back towards the end of 2022 when Democrats were about to, not have their majority in Congress anymore. And I repeatedly said, one of the things they need to do is make an official congressional declaration, hold a vote on it to officially declare January 6, 2021 as an insurrection, right? Put it in the books, official congressional recognition of that day as an insurrection. And that could have solved a lot of problems, right? It could have made it a lot easier to charge these people with insurrection, but Congress didn't do it. Just like they only launched an investigation into Jared Kushner, in October, I think it was, of 2022, right before they lost their majority. So there's a lot of screw ups over the last few years, too many to go around to even count at this point. But yeah, it all comes down to the Democrats don't take action when they need to take action, when they can actually do something. And then at the end of it, they're like, wow, we just didn't have time to do it. We ran out, oopsie-doo. I guess we'll try it next time. And it's continuously frustrating having to use those same talking points basically for the last 20 years that I've been doing this.
If you enjoyed this video, that's because of our members. They make us independent, they make us strong, and they make us honest. Become a member today by hitting the join button below.